Welcome to our YouTube video series on employee payroll and employment law. My name is Christopher Neufeld of Neufeld Legal, and in this particular video we will be discussing pay statement omissions and the impact of employee pay stubs missing critical information. Employee pay statements go by different names, be it a pay statement, pay stub, or statement of earnings and deductions. Nevertheless, the crucial aspect is that they must conform to the specific laws of the jurisdiction in which the employee is employed. As such, you cannot take a template for a pay statement from one jurisdiction, let us say New York State or California, and apply it to another jurisdiction, such as the province of Ontario or Alberta. Instead, the pay statement must strictly conform to the requirements of the jurisdiction, and when it doesn't, not only is it in contravention of the law, but all too often it is failing to disclose improprieties in the payroll calculations and thus employee underpayments. So what we're going to do is look at the differences between the pay statements requirements in certain jurisdictions to enable you to see what those differences are and what information you as an employee might be improperly denied. We will start off with the U.S. jurisdictions from which two of the most significant payroll software providers emanate, that being New Jersey for ADP and Minnesota for Ceridian, and proceed to look at the distinctions found in the provinces of Ontario and Alberta. And what is extremely telling, especially in the case of pay statements for Alberta employees, is that so much of the legally required information under the Alberta Employment Standards Code is missing. And this is not optional pay statement information, it is obligatory pay statement information, which all too often is just the tip of the iceberg with respect to employee payroll and underpayments. Now, in New Jersey, we look to NJSA 34 sub 11-4.6, dissemination of information records. Every employer shall A, notify his employees at the time of hiring of the rate of pay and of the regular pay day designated by the employer in accordance with Section 2. B, notify his employees of any changes in the pay rates or paydays prior to such changes. C, furnish each employee with a statement of deductions made from his wages in accordance with Section 4. For each pay period, those deductions are made. Every employer with 10 or more employees shall, including public employees, shall include in that pay statement 1, the employee's gross wages, 2, the employee's net wages, 3, the employee's rate of pay, and 4, if relevant to the wage calculation, the number of hours worked by the employee during the pay period. Now, in Minnesota, we look to required statement of earnings Minnesota statutes 181.032, which says employers are required to provide each employee with a written statement of earnings. This statement must be issued at the end of each pay period and must include the following: the name of the employee, the hourly rate of pay if applicable, the total number of hours worked by the employee unless exempted from Minnesota statutes chapter 177, the total amount of gross pay earned by the employee during that period, a list of deductions made from the employee's pay, the net amount of pay after all deductions are made, the date on which the pay period ends, and the legal name of the employer and the operating name of the employer if different from the legal name. Now, moving to Ontario, we will quickly look at this one, which is in Section 12 sub 1 of the Ontario Employment Standards Act 2000, which says that on or before an employee's payday, the employer shall give to the employee a written statement setting out A, the pay period for which the wages are being paid, B, the wage rate if there is one, C, the gross amount of wages, and unless the information is provided to the employee in some other manner, how that amount was calculated. D, repealed. E, the amount and purpose of each deduction from wages. F, any amount with respect to room or board that is deemed to have been paid to the employer under subsection 23 sub 2. And G, the net amount of wages being paid to the employee. So already we are seeing some discrepancies as between Ontario and these other jurisdictions, namely New Jersey and Minnesota. But where we really get into some critical differences is when we look at the Alberta Employment Standards Code. And here we start by looking at Section 14 sub 2 of the code, which says, at the end of each pay period, an employer must provide a written statement to each employee setting out, in respect of the employee, A, the information described in subsection 1, and B, the period of employment covered by the statement. So naturally we need to look at Section 14 sub 1 of the Alberta Employment Standards Code to see what information is required in that pay statement. And that is saying every employer must keep an up-to-date record of the following information for each employee. A, regular and overtime hours of work for each workday. B, wage rate and overtime rate. C, earnings paid showing separately each component of the earnings for each pay period. D, deductions from earnings and the reason for each deduction. E, time off instead of overtime pay provided and taken. F, any other information required by the regulations. Now, right away, when we look at this, we see that there are distinct discrepancies. But when we get into this in even more detail, we are going to see where the critical aspects are. Now, what happens all too often is that we start off with 14 sub 1A, regular and overtime hours of work for each workday. This is not discretionary, this is obligatory. It is a requirement that the hours be listed. Now, naturally for hourly employees, we typically see those hours listed out. The problem arises with salaried employees. Salaried employees need to have hours listed. It is not a discretionary element. It is a requirement. You got to keep that record, and you have to disclose it on each and every pay statement. Moving on to 14 sub 1B. Now this is a very big one because people fail to properly understand these concepts if they don't look at them well enough. And that is wage rate and overtime rate. And to understand what these are, you actually have to look at the code itself and not sit blindly say, that's my hourly base rate. That is not what wage rate would appear to be if you actually look at the code. Because at section 1 sub Y, wage rate means the hourly rate of pay for wages. It is not one's base hourly rate. It is not one's regular hourly rate. It is the hourly rate of pay for wages. And wages is a defined term which encompasses a lot of components, what I call wage components, to determine what wages are. And then from there, working backwards, you identify what the hourly rate of those wages are. That is what the definition is saying. It is not saying what is your base hourly rate, what your regular rate is, or otherwise. That might appear in other statutes, but that is not what is being said in the Alberta Employment Standards Code. And what constitutes wages? Well, we look to section 1 sub X, where it says, wages includes salary, pay, money paid for time off instead of overtime pay, commission or remuneration for work, however calculated, but does not include. So before we go into the does not include part, we got to see how expansive and broad this is, especially in the final words. It is remuneration for work. It is whatever is effectively received for undertaking work. And then we look at this. What are the exclusions? I.1. Overtime pay, vacation pay, general holiday pay, and termination pay. So those are out. 2 little I. A payment made as a gift or bonus that is dependent on the discretion of an employer and that is not related to hours of work, production, or efficiency. So before you jump too quickly on excluding bonuses here, what you have to understand is the only ones that are excluded are the ones that can meet the full totality of this definition. And to meet that totality, it has to be dependent on the discretion of the employer and, not or, and it is not related to hours of work, production, or efficiency. And this is what would appear to mess up a lot of people, in that there are very few bonuses or gifts that fall into this classification. It is simply like if you offer everybody $100 for Christmas or a set of towels, that falls into the definition for the exclusion. But what falls in? Almost everything else. 3 little I. Expenses or an allowance provided instead of expenses. And once again, these are there are far more allowances, especially in a province like Alberta, which are not expense related. And thus they fall outside of the exclusion and form part of wages. And finally, tips or other gratuities. Now, so once we do the full encompassment of what is included of wages, we then work our way back and we identify a wage rate based on the wages and put in for the hourly rate of those wages. Critical thing. Second critical thing is overtime rate. And overtime rate, once again, far too quickly do people look at the hourly rate, the base hourly rate, the standard rate is, and simply multiply it by 1.5. And if we go to section 22 sub 1 of the Alberta Employment Standards Code, we see this is not exactly how we calculate, but instead it says an employer must pay an employee overtime pay for overtime hours at an overtime rate that is at least 1.5 times the employee's wage rate. So critical again, we're seeing wage rate. First of all, it has to be listed. Number 2, it has to be wage rate, which in certain circumstances might be one's base hourly rate or one's standard hourly rate, but in most cases is not that. It tends to be higher, at least in our experience, and especially in today's day and age, such that the wage rate, which is not, first of all, being properly listed, and we'll also see that wages are not being properly listed, is the basis upon which we have to come up with the minimum overtime rate. So we next go back to the next aspect, which was 14 sub 1C. Earnings paid showing separately each component of the earnings for each pay period. And what this in fact requires us to do is to find out what those components are that they're talking about. And this is found in the definition of earnings at section 1 sub 1 sub J, where it says earnings means wages, overtime pay, vacation pay, general holiday pay, and termination pay. These are the components that the statute requires you, one, as the employer, to list out in every pay statement. Now, what we often see is we'll see overtime pay when there's overtime pay being paid. Question whether or not it's correct is a different situation, but it is often one of the few that's listed. Vacation pay is a requirement to be listed, as is general holiday pay, also commonly known as statutory holiday pay. Now, with a lot of salaried employees, and even with certain hourly employees, but mainly with salaried employees, there is a tendency to see, in certain circumstances, vacation pay and general holiday pay not being listed whatsoever in the pay statements over the course of a year. And we talk about this in other videos, and that is based on the fact that it is premised off of the concept of paid vacation, which is not a concept that one finds in Canada with respect to its employment standards legislation. In Canada, what we find is vacation days and vacation pay, general holidays and general holiday pay. In each two distinct concepts, and as we talk about in other videos, distinct from the American concept of paid vacation, which is drawn out largely from contractual arrangements. But at the end of the day, it's required that whenever vacation pay is in fact paid, it must be listed. And when general holiday pay is required to be paid, it must be listed. And when it's not listed, that's an issue, because there are in fact different calculations that exist for each of these elements, which in fact derive different minimums and oftentimes different outcomes as to what those payments are. And we discuss this, and what's actually often best is actually see it with the actual numbers themselves. But those elements are required. Now, the most critical one, the most overlooked one, is the first earnings component, and that is wages. Now, we talked about wages briefly before in the definition of wages 1 sub 1x sub x, where there are many wage components that are brought in together to form wages. And the code does not say you got to talk about in different parts what those components are. You have to provide instead, based on 14 sub 1 and 14 sub 2, wages. So what the code is actually saying is you have to have a number for wages. And that number has to be a composite that adds in all those various components for the period. It excludes overtime pay, vacation pay, general holiday pay, and termination pay. But it includes not only the hourly or salary pay that one receives, but other remuneration, which can be bonuses, incentives, allowances, premiums. And most importantly, in the province of Alberta, which is all too often overlooked, is employer contributions, because that's remuneration that somebody receives. And this is employer contributions towards pension plans, RSP plans, health and dental benefits, insurance, and the like. And all those aspects need to be counted up and provided in a single number. And why is this particularly important? How does this tie into the other elements that we talked about? Well, first of all, if we list out wages, what we find is that once wages are properly listed, we can then go back to what the definition of wage rate is at 11Y and find out what our hourly rate is for wages, which is our wage rate. Important concept. And once we find out what our wage rate is, we then can define what our minimum overtime rate is. And if you actually look at each of these elements step by step, I think you will see that there is considerable discrepancy in the output. And if there's discrepancy in the output, what that tells us is that there is extreme importance in getting the numbers. And the fact of the matter is that the code is quite clear in the fact that These aspects cannot be omitted. They must be set out, because once they are set out, people are able to make the particular calculations required to identify what their minimums are, to identify how much they are owed. Because what in our professional estimation this shows all too often is that overtime pay, general holiday pay, vacation pay, termination pay in lieu of notice are not being correctly calculated in accordance with the code. And the reason that most people don't see this is because the pay statement has improperly omitted these aspects. These are the critical aspects in the code for what pay statements must include. And you can't get around them. There is no variance that some companies are allowed to only fulfill 60%, or what in fact might be 40% of the obligations. Because what we see is too many of these aspects are not being satisfied. But what do we see when we look at it? Go back to earlier in the video when we discuss in particular New Jersey and Massachusetts as to what the pay statement requirements are. Going back and looking at that, what you see is for an employee in Alberta, compliance with the state of New Jersey's pay statement requirements, compliance with the state of Minnesota's pay statement requirements. The question then becomes, did that employee in fact work in New Jersey or Minnesota so as to make them and their employer beholden to those laws? No. If they were working in the province of Alberta, it means absolutely nothing. And there's no legal compliance with the laws of another jurisdiction. What you need is compliance with the laws in one's own jurisdiction where one is working. And those obligations are set out, for example, in Alberta at Section 14 Sub 1 and 14 Sub 2 of the Alberta Employment Standards Code. And as with other provinces in Canada, there is a need to follow the specific requirements. You can have additional information provided. You can have alternate information provided, but the base minimum requirements must be fulfilled. And you can't say, well, I comply with some other jurisdictions' pay statement requirements. That's not a good reason in the law. The law doesn't allow you to do that. The law says you can put whatever you want in there, but you have to fulfill the basic statutory minimums. And for purposes of doing that, you have to look at the specific laws of the jurisdiction in which an employee is employed. And in certain cases, and all too often in Canada, and in particular from what we see in Alberta, is we do not see that type of compliance with the Alberta Employment Standards Code's pay statement requirements. And this, if you do achieve that compliance, or you correct for that for non-compliance, I should be saying, once you do the corrections and you do obtain the numbers, what we're seeing all too often, unfortunately, is that there are significant underpayments that are arising. And it starts off by failing to satisfy the statutory requirements set out in the legislation. So, take the time, review your employment statement as against the specific pay statement requirements of your jurisdiction of employment. And if they are not consistent and do not fulfill all the requirements of the laws in your particular jurisdiction, that's when you can say there might very well be a significant issue that needs to be addressed. And you have to then proceed cautiously but correctly. And oftentimes the best thing to do is to talk to a lawyer admitted to practice in your particular jurisdiction, who can then explain to you what is happening and where everything stands. Because as we see and what we explained in Alberta, there are clear requirements that are distinct from other jurisdictions in the province of Alberta, and they make significant differences. They create significant outcomes that differentiate between one jurisdiction and another. But it's the tip of the iceberg, as we said at the beginning, that shows that there is a fallacy, mistakes being done, and it starts with incorrect pay statement preparation. And when you start with an incorrect pay statement preparation, and that they're not being presented correctly, and you're not getting the information from which to properly work off of, what happens all too often is the employer is doing the exact same thing and not utilizing the correct information with which to undertake the work that it needs to do and get you the correct payments that are consistent with the laws of the jurisdiction within which you are employed. And that is very critical for you if you want to make sure that you're getting properly and fully paid in accordance with the laws of the jurisdiction within which you are working. Thank you.